I am Government Affairs Advisor to Worldwide ERC. In more specific terms, I advise the Worldwide ERC Government Affairs Committee as well as the Government Affairs Forum leadership on various policy issues. For the past, almost 2.5, 3 years now, I've been closely following the Brexit referendum on behalf of Worldwide ERC, and in particular for our global and immigration forums, as obviously the Brexit and the UK potentially and likely leaving the EU will have a very dramatic impact on mobility workforce issues. We also have been keeping the membership apprised of different issues with Brexit through communications from Worldwide ERC President and CEO Peggy Smith, with kind of noteworthy events, votes in Parliament, decisions by the EU regarding Brexit, and we will continue to do so as this issue unfolds. What I am going to start off today with, though, is giving everyone kind of a very brief overview of how we got to where we are today with Brexit, from primarily a American's layman's perspective here, and later on we will have the UK team from KPMG, who is very living and breathing this obviously on a daily basis, and much more in-depth knowledge about the specifics and the implications for the mobility industry. But let's kick off on when this all began. So June 23rd, 2016, then Prime Minister David Cameron had called for a referendum for the UK to leave the EU. By all accounts, he didn't think that the referendum would ever happen, as he had made the promise when he had needed to develop a coalition government, and didn't think that the Conservatives, his party, would take control, but they did. So he had to follow through on that commitment, and on June 23rd, 2016, the referendum was held, and it won by a small majority, but doesn't matter, it still won, 51.9 to 48.1%. And Cameron had done it in large part to quell some of the Conservatives who and others who had wanted to leave the EU. So because of this, he resigned the day after, and unlike the U.S., where the general population elects its presidents, in the UK, it's the party in power that determines who the prime minister or the leader for the country will be. So the Conservatives then elected Theresa May to become the new prime minister to work through with the EU terms for Brexit. And on February 2nd of 2017, we actually saw the UK government publish its white paper on Brexit and what the UK saw as kind of the vision and future for the relationship with the EU. But just to be clear, that's what the UK had wanted to see. And then on March 29, 2017, we saw Prime Minister Theresa May actually trigger Article 50 of the Lisbon Treaty, which is the terms for the European Union, and essentially started the clock on the UK leaving the EU, which is a 2-year time frame, although there can be an extension. Then we saw Theresa May also making a decision, and unlike in the U.S., where we just have elections and they're very scheduled every 2 years for House of Representatives and 1/3 of the Senate, the Prime Minister does have the authority and the leader of her party to call for a special election, which she did, hoping that the Conservatives would gain seats within the Parliament in order to gain support and strength before going into negotiations with the European on a Brexit deal. However, it ended up that the Conservatives lost seats, lost a majority, and then had to create a coalition government partnering with the Northern Irish Democratic Unionist Party to maintain control of the government. After we got through a lot of the internal UK procedures and processes, we then saw the formal negotiations begin between the UK and EU on June 26, 2017. Through that time frame, they reached agreements on a number of different key kind of items, including a transition period to give kind of an overlap between when the March 29th date and then giving them more time to kind of transition out, because obviously a lot of the UK law is embedded in the EU structure. They also decided on the status of EU citizens in the UK and vice versa. Then we finally saw on November 14th an actual withdrawal agreement that was negotiated between Prime Minister Theresa May and her officials, as well as officials from the EU. Immediately received quite a bit of criticism from both sides, from those who wanted to leave the EU, as well as from those who didn't. And we actually saw members of her cabinet resign over the deal, even including her cabinet minister who had negotiated the deal on behalf of the UK in opposition of the agreement. Then in early December, there was originally going to be a vote lined up, but when Theresa May saw that she did not have the votes necessary, she delayed the vote. And her party, members of her party, I think there need to be 75, but maybe not. But a large number of her party need to sign a letter to demonstrate whether or not there should be a vote of no confidence. She survived that vote on December 11th, 2018. She then went back and worked with the EU, which held a pretty hard line with the UK, because they want to demonstrate, obviously, to other countries that they need to remain part of the EU, and they're not going to leave on favorable terms if they try to trigger Article 50. So we recently, on January 15th, actually saw the actual vote for Parliament, in which they overwhelmingly rejected the deal, 432 to 202. I believe that's the largest defeat for a government proposal in about 100 years. So a very devastating outcome. And Theresa May had until last Monday to come up with an alternative, which she has done. It doesn't change a whole lot from the initial deal. And we're likely to see on January 29th a new vote on that deal, as well as different amendments to that, ranging from kind of setting up for maybe a new referendum or dealing with certain aspects of the deal to make it more palatable to certain aspects of members of Parliament. So we've got not a whole lot of time here. Brexit Day is actually coming up just at the end of March, and then even under the current agreement, the end of the transition period isn't too far away, with 2020 to transfer over. So just quickly, while our folks at KPMG will get into kind of the immigration and Social Security aspects of both a deal or no deal with Brexit, there's going to be a larger implication for mobility, not just for transferees, but also where we see companies move their operations, whether or not they're going to have both a UK operation as well as in the EU, because largely the two will be separate. So a lot of folks are looking at those parameters right now. And also something that needs to be taken into consideration that folks at my firm have been looking at is the fact that really the UK has been in the past a strong partner from the US in communicating and positioning kind of interest of the U.S. before the EU. So the U.S. is actually going to lose a very strategic partner within the EU when the UK actually leaves the European Union. We're also likely to see, as far as just business travel, personal travel, a lot of delays and other issues that could come up as a result of in particular, hard Brexit of the UK from the EU. And with that, I'm going to go ahead and hand it over to Chris to introduce his team and take you through the real details of Brexit. Chris?
Thank you, Tristan. Hello, everyone, and thank you for joining us today. My name is Chris Hawkes, and as well as being a Globe Mobility Advisor, I lead the Globe Mobility Brexit team at KPMG in the UK. I'm going to introduce my colleagues, Denise, Laura, and Hashina, as we go through the topics of immigration, social security, and mobility, with our theme being, what are the Brexit impacts on cross-border workers, and what are employers doing to be ready? As has been mentioned, there is a Q&A feature in the webinar, and so if you have any questions as we go along, please do just type them, and we'll do our best to answer them at the end or include them in our content as we go along. We've been working with a wide range of businesses as they carry out planning for the potential Brexit impact on their businesses, and we want to share that information with you today. And in particular, we're going to be focusing on the issues and challenges related to people and Brexit. Importantly, we're going to be looking at the practical issues and actions that your organisations can take now to be ready for any potential outcome as Brexit events continue to unfold. Thank you, Tristan, for your summary, and I'll now add some additional points on the current state of Brexit in the UK and our advice to organisations for readiness. So at KPMG UK, we've developed a Brexit Navigator, an online resource that helps answer the key questions of what an organisation should do and when they should do it. We'll touch on some of these points today, but I would recommend you take a more detailed look after our session, and you can find it at our KPMG Brexit website. So as Tristan outlined, it's been an eventful few weeks in UK politics, and more is still to come. What has been described as Plan B is now in debate in the UK Parliament, and the primary challenge is going to be understanding what consensus can be reached to agree a deal that avoids the cliff edge type of a no-deal Brexit. It is important to note that no deal is still possible. Without further action, the legal outcome is that the 29th of March 2019 is Brexit Day. The UK officially leaves the European Union at 11 p.m. UK time. There's a number of outcomes that are being debated at the moment, and at the current time there is debate in the political circles on all of those, and in the next few days we'll see if any of them move towards reality. This all potentially leaves doubt of what happens next, and as a result some organisations have still not taken steps to be ready for Brexit because they think the outcome is too uncertain. We advise against this. Much has already been agreed and is known about what will happen with Brexit, especially in the event of no deal, and in particular with regard to people. So as a result, we recommend all organisations plan accordingly, and in particular review their business and workforce plans with a no-deal Brexit in mind. So with that sort of introduction complete, I'm now going to ask Denise, our immigration expert, to take us through where we are now and what organisations can do to be ready and support their workforce.
Hello, thank you very much, Chris. My name is Denise Osterwald. You might be able to tell from my last name that I am not a native British citizen. I am actually originally German, so I'm coming at this whole Brexit construct essentially from two directions. One is a legal advisor to businesses, who tries to advise in a pragmatic and sort of hands-on way what needs to be done to get ready for Brexit. But I am also directly affected by everything that is going on, so that gives me a bit of a unique insight into how employees might be feeling and how employers can help their employees to get a bit more comfortable with what's happening in the UK. So I split the information into a deal and a no deal scenario because, as Chris was just saying, both are a distinct possibility at this point in time still. So the deal would be based on the UK Parliament voting to accept what is in front of them at this point in time, and the UK and the EU will agree that this deal is what will govern the next 2 years, and that would have to be agreed before the 29th of March 2019. What will happen in a deal situation is that what's called free movement of people across Europe, across the EU, will continue. That means everything stays as is, and people can still come and go across Europe if they are European nationals, as they have always been able to do. There will be an implementation period, and that will last until the 31st of December 2020. While the implementation period is underway, there is a registration scheme that the UK has introduced. Because different from many other European countries, the EU currently doesn't have a mandatory registration system for European nationals when they come into the UK. So this new registration system actually went live for a limited number of people on Monday. It will be fully live for all European nationals in the UK by the end of March 2019, and it will run until the 30th of June 2021. And everybody who has been in the UK by the end of the implementation period will have to make an application under that system. There is very little exception, so it is very likely that almost all of the 4 million Europeans in the UK will have to utilize this system to declare their presence in the UK to the UK authorities. And there are essentially 2 new immigration statuses that have come into play since Brexit. One is called settled status, and this is for all Europeans who have resided in the UK for 5 continuous years. Those who aren't here for 5 years continuously by the end of the implementation period must also apply, though they will apply for something called pre-settled status. And they will then have the opportunity to clock up 5 years in the UK, and then they need to swap their document for a settled status document. Family members are also affected by Brexit, but mostly as long as they are coming to the UK before the 31st of December 2020, they will be eligible to apply under the same scheme. There is, under a deal scenario, an option for family members to come to the UK after the end of the implementation period, as long as they were already considered family members at the end of the implementation period in December 2020. Under a deal, all rights and benefits for EU nationals will continue as they are currently enjoying them. And as I mentioned, the scheme is currently being trialed since Monday with some EU nationals and their non-EU family members. And actually, you might have heard that the system was meant to cost £65 per application. However, in order to try and garner some support and some goodwill amongst the politicians and the general public, Theresa May has declared already on Monday that the £65 will be waived. For all of those who make an application that are required to pay, they will get a refund, and then they are looking at arranging the system so that it won't ask for the £65 anymore. However, they're not entirely sure yet when that will be updated. So now we're coming to the no-deal scenario, which means that on the 29th of March, the UK leaves the EU without having agreed any kind of a deal, or one of the possibilities that was mentioned before is the extension of Article 50 if all other 27 EU countries agree. Now, the approach that the UK government has taken in a no-deal scenario is based on the withdrawal agreement, but it is slightly less generous. There isn't that much difference. It's mainly condensed timelines that we're looking at. So under a no-deal scenario, only EU nationals resident in the UK on the 29th of March will have their rights protected, whereas under a deal that would have been extended to the 31st of December 2020. They will still be able to work, study, and access benefits and services as they have done before Brexit. And they will also, under a no-deal scenario, have to make an application via this new registration scheme, which is called the EU Settlement Scheme. The hard deadline for applications under a no-deal scenario is the 31st of December 2020, whereas under a deal it would have given an extra 6 months for people to make applications still. They have confirmed that until December 2020, EU passports and ID cards will be sufficient proof of right to live and work in the UK. you may know that a lot of European countries issue passports as well as legal identification cards. Currently, it's one of the perks of being in the European Union that you can travel around the European Union with just the ID card. You don't have to have a passport. The rules regarding family members joining after the 29th of March are more restrictive and slightly more complicated than they would be under a deal scenario. The government has also confirmed that so-called frontier workers, which essentially are commuters really, so let's say they work in the UK for 2, 3, 4 days a week and then they go back to another European country, will be able to continue their working pattern, and if they qualify can either apply under the new registration system, or the government will in due course release some other type of system under which they can apply. We don't know more about that system yet because it hasn't been announced. A big difference between a deal and a no-deal scenario is that under a no-deal scenario, all European laws will fall away on the 29th of March, instead at the end of the transition or implementation period, and therefore there will be no recourse to European institutions under a no-deal scenario. So while at the moment a European national who feels aggrieved about how the UK has treated him or her can go to the European Court of Justice, in a no-deal scenario that wouldn't be possible anymore. And the government has also confirmed that beyond December 2020, the EU ID cards I just mentioned may no longer be recognized and full passports will be needed. There has, unfortunately and quite unhelpfully, not been any information on the regime for EU nationals coming to the UK from the 30th of March. So for the moment, we are assuming that the government will not pull down the shutters and not let any Europeans into the country anymore from the 30th of March, or indeed require visas to be applied for before they come, because there simply is no infrastructure in place to be able to accommodate the additional volume that would be required to be issued in terms of visas. So we are assuming that for the time being, they can just come to the UK, and at some point in the future, the UK government will work out how they will be captured and how they will be distinguished from those Europeans who have been here before the 29th of March. And many European countries have now released information on the status of UK nationals and their jurisdictions. They've been a little bit slower than the UK on that part because they were waiting essentially to see what was happening in the UK. But by and large, what they are saying is there will be a transition period for those already in the UK, for those already in their countries, and then they will also have to make applications under the relevant country system. So what does that mean for visa-free travel post-Brexit? Well, the UK has agreed not to require UK citizens to obtain visas before traveling for tourism, short visits, or business visits to the Schengen area. The Schengen area is essentially a specific area within Europe that allows travel without even having to have an ID card. So you can go from Germany to the Netherlands, for example, you can cross the border and you don't have to show any passport or ID card. And that is going to be the case in a deal or no deal. However, in a no-deal scenario, EU countries that aren't part of Schengen may require visit visas, so that is something to look out for. And there's also specific requirements for passports that you have to comply with to get into the Schengen area. So in a no-deal scenario, worth checking if you are a UK national traveling into the Schengen area. Visas for work in the EU will be required for UK nationals if there is a no deal, and common European visas will disappear. There are some specific concessions that allow visa holders to travel across Europe slightly more easily. They will also fall away in a no deal scenario. And then from the 1st of January 2021, the EU will introduce what's called the European Travel Information and Authorization System, which is very much akin to the US ESTA, which requires all third country nationals, so all non-EU nationals, to obtain electronic permission to enter the EU before traveling. And then from January 2021, there will be a whole new immigration system in the UK. Unless there is a preferential treatment agreed between the EU and the UK in any trade agreement going forward, it will treat the EU nationals and non-EU nationals exactly the same. And the government is currently consulting with businesses regarding amending the current immigration system to allow for the increased number of applicants. Now, while most of the changes they are proposing tend to be positive, there's currently a bit of a discussion around the requirement to have a minimum salary of £30,000, because obviously that is For London, not so much a massive problem, but if you go further out into the regions across the UK, that is a fairly high salary. So the important thing to remember is, while it all sounds very messy and very complicated, and it sounds like we don't really have any concrete information that you could pass on to employees, there is actually a lot that we do know. The first thing we always suggest is that you undertake a people analysis and see how many people you have that are affected by Brexit, and which functions they sit in. Are they condensed in a particular area in your business? And then based on the outcome, decide on what you can do to support them, if you can do something. And there are lots of different options. They are from very much hands-off to just providing information, to all the way to supporting individuals with their applications, and lots of things in between. You can see on the slide here, we've kind of split them up into 4 quadrants, depending on how many European nationals you have and how critical their skills are to your business. And then lastly, what you want to do is start future-proofing your organization. Look at your recruitment and retention strategies. Do you need to adjust them? Because it's very likely that your pipeline of European nationals in the UK and vice versa will be restricted post-Brexit. Look at your global mobility policies. Do they need to be adjusted to take account of the increased timelines, of the increased costs? Because in the future, you will need to obtain visas for EU nationals coming into the UK, and again, vice versa. And the really important thing on this is the earlier you engage your employees now, the easier it will be for you in the future to comply with your right to work requirements and the legalities of employing EU workers in the UK. Because at some point, the checks that you will have to undertake on European nationals will become very similar to the ones that you have to undertake on non-European nationals. And the more you can engage with your workforce now to encourage them to apply under this new system and get all the immigration paperwork in place, the easier it will be for you further down the line to tick off boxes once the government makes the changes to the system. And that is it for me.
Thank you, Denise. That gives us a really good overview of the current state of affairs. Thank you very much for going through all of that. And I can already see some of the questions. We're going to be having you back in a short while just to answer some extra pieces of information. What we're going to do now is move on to Laura Hutton, an expert in Social Security. And I'm going to ask her to take us through a topic that I don't think has had a lot of press, but personally I think is one of the major factors of Brexit, especially in the mobility world. It's a key area in the withdrawal agreement and for the future of cross-border working. So Laura, please.
Thanks very much, Chris. So I wanted to start just by talking a little bit about the place that Social Security has in the heart of Europeans. It is quite an emotive topic in Europe. So from a US perspective, Social Security is typically seen as the payment of FICA in exchange for a Social Security pension. In Europe, Social Security contributions vary widely in cost between countries, and also the benefits that you receive in return for paying your contributions vary, but it typically includes things including pension, unemployment benefits, child benefits, maternity rights, healthcare. So it is a considerable range of benefits, and some of them are extremely valuable. So the prospect of change to someone's Social Security contributions and benefit entitlements is quite unsettling. So in essence, similar to what Denise has done, I am going to look at this from 2 perspectives. I'm going to look at it from the perspective of if we have a deal, and I'm going to look at it from a no-deal perspective. So if we finally get agreement on a deal, which will involve a transition period, as Denise says, the transition period, which will extend to the 31st of December 2020, will essentially be a period of time in which nothing will change from a Social Security perspective. So the regulations which currently apply to govern people moving between European countries will continue to apply to those moving between the UK and Europe. And what that means essentially is that those moving on a temporary assignment will typically get up to 5 years of contributions coverage in their home country, and typically contributions made in different European countries will be aggregated for the purposes of establishing someone's entitlement to benefits. So those rules will continue to apply to UK-Europe moves in the event of a deal. However, in the event of no deal, the UK will leave the EU on the evening of the 29th of March, and essentially that will be a cliff edge. So the European regulations will no longer govern people moving between the UK and Europe as of the 30th of March. And the trouble we have there is that it isn't entirely clear what will follow. So there is a great deal of uncertainty, but there are some things that we know. Firstly, touching in a little bit more detail on what we will see if there is a withdrawal agreement, the draft withdrawal agreement contains a whole section with provisions on social security, as I say, because it is so important to Europeans. And it divides people into three categories. Firstly, there is a category of people who were only mobile prior to the end of the transition period, and those individuals will find their social security position governed entirely by the European regulations. So that essentially, there's no need to consider the new rules for them. Employees who are mobile at the 31st of December 2020, the European regulations will continue to apply to that population for so long as their situation remains unchanged, which is good news from a continuity perspective, but obviously what we don't know is whether or not what will constitute a change. Relatively minor changes to assignment length or travel pattern might constitute a change, which would then flip the individual into whatever the new rules ultimately look like. Thirdly, there will be employees who are mobile only after the end of the transition period, and they, as you would expect, will fall straight into the new regime, and there will be no consideration for them of the European Social Security regulations. So what that means for employers is that in the event of a withdrawal agreement, they will be looking at different populations subject to different rules, potentially for quite lengthy periods of time. So it will be difficult to manage and quite complicated, but at least there will be a degree of certainty for the next 2 years roughly, which allows employers to spend a little bit more time planning for the future. So if there is no deal, or indeed after the end of the transition period, what then does the social security world look like? Well, first of all, the UK in December put forward its own version of what it wants the rules to look like. And the first thing is what they did was they took the European Social Security regulations as they are and essentially imported them into UK law and then unilaterally made changes to the regulations to take account of the flexibility that they believe they need in the event that other European countries don't cooperate or agree with the UK's approach. So the sort of underlying principle is, therefore, that the UK wants rules similar to the current European regulations to continue to apply to mobile employees. And again, that's good news. So typically that would mean that someone moving for up to 2 years would remain in their home country social security system on a compulsory basis. They have said, however, and they've put this change into the draft regulations, that if they don't get cooperation from other European countries, then what will happen is that the UK by default will seek payment of UK contributions on UK source income, in other words, on income that relates to work carried out in the UK. And that has the potential to create contribution liabilities in 2 countries at once, but also contribution liabilities on the same income, so double liabilities. Because if the other country happens to impose contributions on 100% of income, and the UK wants its contributions on the portion that relates to work carried out in the UK, then you will have a double liability, thereby increasing the cost both for the individual employee and for the employer. There's also a quirk in the current draft rules that suggests that if there are any bilateral social security agreements between the UK and the other European country, that those will trump these new draft regulations, which is an odd outcome because, as I'm just about to come on to, the bilateral agreements that do exist are not particularly helpful. So talking of those bilateral agreements, the UK actually has bilateral social security agreements predating its membership of the European Union with, I would say, 2/3, if not 3/4, of European countries. The problem is that because they were negotiated such a long time ago, they're not really fit for purpose in the modern world. So, for example, the UK-France bilateral social security agreement only allows people to remain in their home country social security system for moves of up to 6 months. It's a very limited period of time before someone will be forced into a social security system other than their home system. In addition, bilateral agreements typically don't make any provision for people who work in more than one country, what is called a multi-state worker under European regulations. And again, because we have increasing numbers of commuters and business travelers and all sorts of informal mobility, provisions that govern this type of travel are really important and necessary. So there will be uncertainty and confusion for that type of population. The other thing that the bilateral agreements don't particularly do well is the aggregation of contributions for benefit entitlement purposes. Most of the agreements cover aggregation of contributions for pension, but not for purposes such as unemployment insurance or healthcare. So again, potential challenges there. And we have to take into account the fact that this is the UK view, but the European Union countries' views are also relevant here. And the European Commission has said that it's up to each individual European country to take its own position with respect to social security vis-à-vis the UK after Brexit. So we could, in theory, have 27 different perspectives. Certainly, you can expect a patchwork of opinions. So the European Union countries have not reached a consistent view, for example, on whether those bilateral social security agreements are actually still valid. So some countries say that the agreements are valid and others that they potentially are not. Those that have published their view on social security post-Brexit look as though they do want to cooperate with the UK in establishing rules similar to those currently applicable to European Union travel. So again, that's good news. But if there is no agreement with a country, for example, such as Poland, where the UK currently has no bilateral agreement with Poland, then that becomes a move between non-agreement countries. And again, that can create double contributions liabilities and no aggregation of benefit entitlement. So potentially really quite challenging there. So just in coming towards the end of what I wanted to say, I just want to move on to thinking about what employers can do and what I'm seeing employers doing now increasingly. The first thing is to look at it from a cost perspective. So modeling costs based on the potential for contributions to be paid in a different location. That's particularly important for businesses where employee costs are a big part of pricing when pitching for client projects. And so to the extent that we have seen some companies restructuring or developing alternative resourcing strategies where the individual currently carrying out a role is going to become considerably more expensive and is not mission critical, if you like. The second thing employers are doing is looking at it from a benefits perspective, evaluating whether their employees are going to be affected by change in their benefit entitlement, potentially developing mitigation strategies, but certainly planning to communicate those changes to their employees so that forewarned is essentially forearmed to the extent possible. And then finally, there is a complexity angle to this too, as I'm sure has become clear from what I've spent the last 10 minutes or so discussing. So there are different implications arising dependent on whether or not we get a deal. There are the potential for liabilities to arise in multiple countries, maybe on the same income, but even if not, there's going to be payroll complexity in getting the contributions paid across in multiple countries at the same time. There's also the fact that Social Security has often been an afterthought for employers moving employees between countries, but now it's really very important that they're able to evidence their employees' Social Security position in order to maximise the period of certainty under the outgoing European regulations. So getting the paperwork in place to be able to do that is important. And then just preparing to manage these two sets of rules that could well run in tandem for quite some time, the previous European regulations and the new world, whatever that turns out to look like. So I think really that's what I wanted to talk about today, and I am going to hand back.
Thank you, Laura. It's, as you said, it's a complicated area, but for me, it's a really, really important one that doesn't make necessarily the main news, but from a global mobility people, what's happening with Social Security is going to be essential to understand. So our final topic for today is to focus on mobility, particularly what we're seeing in the activity here in UK and Europe. And Hashina, a global mobility advisor in our London team, is going to take us through some of those details.
Great, thank you, Chris. So what we're going to talk about is some of the mobility-related complexities that many organisations will be experiencing as a result of Brexit. So whilst we don't know exactly what the landscape post-Brexit will be like, there are real practical steps that can be taken with regard to mobility planning. And in fact, the detail here on the slide should not be alien to anyone in a HR, mobility or tax function. So first things first, an initial step that we are seeing a lot of businesses take is to gather their key stakeholders. So even at this stage, HR and global mobility often don't have a seat at the table in a business's Brexit discussion. Ensuring mobility planning is considered means key people issues won't be overlooked. It's also important that you are also thinking about your external stakeholders, such as your suppliers and customers. What are they doing with their people in relation to Brexit? And are your vendors ready to assist you? Next, a data gathering exercise is also a vital step for a lot of businesses. Do you know your Brexit population in terms of those EU nationals in the UK and UK nationals in the EU, whether it's on a permanent assignment basis or as business travellers? A first step for HR mobility and tax teams is to understand this population. Where are these employees based? What is their situation, for example, around their work visa, permit status, and what about their family and their dependents? A key point to also understand is whose relocation is critical to the business and who has skills which you cannot afford to lose. In a no-deal scenario, it is potentially possible that there will be very limited travel between the UK and the EU for a number of months due to potential invalid work visas and permits for those populations affected. What will you do if critical business people cannot travel from the EU to the UK or vice versa? Can your organisation survive if only limited travel can occur? All of this is vital for relocation and mobility planning and will help inform policy and employee support and any incentives that you may decide to offer. And as Denise and Laura mentioned earlier, businesses should understand their employees' immigration and social security position so that once the rules post-Brexit are fully known, the business has the data that they need to act quickly. We're also seeing that new location analysis is also a step that businesses are completing. So where a business needs to relocate its employees to a new location, or it needs to move employees in much bigger numbers than it has done previously to a location, they should take a deep dive into what this location is like. So firstly, in terms of the local infrastructure and the lifestyle, you should also understand any pinch points and local amenities. So for example, is it difficult to obtain schooling for individuals that have children? So you need to understand and plan ahead for the support that you might need to offer employees as part of their move. It's also important to understand what the tax and the social security costs for the employee and you as a business would be in moving employees to this location. And cost modelling is a really important step for a business, in particular for budgeting and accounting purposes. It's also important to understand the impact on net pay for your employees, and you can then plan around this accordingly. You also have to think about offering certain incentives to employees to move. Also, various locations across the EU have some form of beneficial expatriate tax regime or special reliefs for inbound employees. So it's worth understanding all of these for your own cost modelling purposes, but also for discussions with employees about their relocation. And now touching upon the employee support and policy bubble. So if you're relocating employees or you're expecting employees to work cross-border as a result of Brexit, you should have a mobility policy in place for this. You should review your existing mobility policies to understand if they encompass the expected Brexit population and then all the challenges that go with these employees moving or working cross-border. And lastly, I just want to pick up on the commuter and travelling point as well. So whilst a lot of Brexit mobility involves permanent relocations, we are also seeing a new spectrum of business travellers and commuters as a result of Brexit. We are regularly seeing changes to business travel lanes as employees are required to work in different locations than they were previously, or higher numbers are required to work in a particular location, and that's because of changes in corporate structure and new entities and functions being established in new countries. In addition, we are also seeing an increase in commuters whose jobs relocate out of the UK to elsewhere in the EU, but their family remains in the UK, and so they're commuting to the UK to spend time with their families on weekends and a small number of work days each week. This creates added complexity as employees can be taxable in more than one location, and employers often need to operate withholding in both the UK and the new location at the same time. So overall, it's really important to that businesses are tracking their business travellers and their commuters and have a mechanism in place to assess any tax and social security liabilities and compliance actions required for these employees.
Thank you, Sheena. I think it's the time left, then it's best for us to move on to some questions that we've had. I've had quite a few questions coming through, so I'm going to combine them together, a few of them, and we'll go from there. So, Denise, if it's okay, first, for quite a few different questions, but the first one I was going to just put to you was, could you maybe just explain, you touched on it in your presentation, but just explain the difference between settled and pre-settled status, please.
So the settled status is for those who have been in the UK for 5 years or more in a deal scenario by December 2020, in a no deal scenario by the 29th of March 2019. So for settled status to apply to you, you have to have lived in the UK for 5 continuous years. If you have not lived in the UK for 5 continuous years, you still have to make an application under the new registration system. However, you would only qualify for something called pre-settled status. So let's say you've been here for 2 years, or if there is a deal, you come during the implementation period, you apply for pre-settled status, and then you are given the opportunity to clock up 5 continuous years in the UK, and then you would swap your pre-settled status for settled status.
Thank you very much. I'm going to come back to you straight with another question, if that's okay.
Sure.
So we've had a couple of questions on a specific topic of frontier workers, and I wonder if you would just give us a definition and just a little commentary about what we know about frontier workers at the moment, please.
So frontier workers are a specific term that is used by the European Union, and they are workers who tend to work in one European country and live in another. So this could be somebody who lives, let's say it's a German national who lives very close to the Dutch border, and they go over to the Netherlands every day to work, and in the evening they pop across the border back to Germany where they live. Or it can also be people who work from Monday to Friday, let's say, in the UK at the moment, and then pop back to their country where they live, the other European country, for the weekend. So as long as you return to your country of residence at least once a week, you are considered to be a frontier worker. And those frontier workers at the moment haven't got a specific regime. The UK has said for frontier workers into the UK, if they qualify under the registration system, they should make an application for pre-settled or settled status. And if they do not qualify under that status, They will still be able to continue their work pattern for the moment. However, there is likely to be some other type of application that they will need to make to get a piece of paper that confirms their status as frontier workers.
Thank you very much. So just returning to our topic of Social Security, Laura, we've had a couple of questions coming in on the specific topic of the European Health Insurance Card, which I know is something that has been a discussion in the technical rounds. Do you want to please tell us what that is and give us a bit of an idea of how important it is and also what might be happening there, please?
Sure. So the European Health Insurance Card is a card that you can apply for from your home country, which entitles you to any medical care which may become necessary when you travel elsewhere in Europe. And I mean, I have a European Health Insurance Card. It's something that almost everyone holds. So it is part of the European Social Security regulations, and therefore, very possibly, it will disappear either as of the 29th of March or the 31st of December 2020. However, it's not particularly from a mobile employee perspective, but it is particularly important to the UK and indeed to other European countries because of the large number of pensioners who live outside their original home country, a large number of students, and also holidaymakers. So I would be more inclined to see room for a deal on this than potentially some of the other social security issues. So I think we can still hope that there will be some replacement for the European Health Insurance Card.
Thank you. Hopefully that was there's a couple of people that asked about that. Hopefully that was the detail that was good there. There's been a particular question about talking on a couple of questions actually, just going back to the mobility policies and examples of cross-border mobility policies that encompass the Brexit population. I think the examples that we would refer to, we are seeing specific mobility policies relate to Brexit mobility. And in particular, that type of Brexit mobility is very live and beginning at the moment. And one of the areas that we're seeing as a particularly new type of mobility is one that Ashina was just referring to, which was commuters, whereby individuals who are having to move from the UK because their roles are moving to a new EU location are not yet ready to be moved with their family, and so that they are reverse commuting is a term that we use to describe it back to the UK. I think the other areas that we're seeing in policy development is again in the areas of I wouldn't exactly describe it as incentivization, but the types of things that these individuals are going to need to support in this quite unique situation where they're being asked to move to new roles in the EU. Coming back to questions related to immigration, what I was going to pick up next was, I think, quite an interesting area, Denise, one that's probably quite complicated, but it's something that we've been trying to distill as a simple message as possible, certainly in the last few days as the political debate continues, which is if you're an EU national, not currently in the UK, but thinking or wondering about moving to the UK, what are the sort of things that you need to think about in a deal, no deal situation?
So we do actually have clients who have asked this question. I think the first thing to think about as an EU national is whether you have lived here continuously for 5 years before you left and would therefore potentially already qualify for settled status. You would have to make sure that deal or no deal at the moment, you are not outside the UK for more than 2 years if you have acquired permanent residence or settled status. So if you have acquired 5 years living in the UK, make sure that you come back before a continuous period of 2 years has elapsed, because that will mean you will retain that status that you have already obtained. If you are in the process of accumulating 5 years, but you haven't got them yet, you need to make sure that you are not outside of the UK for more than 6 months, because that would break your continuous residence. And if you come back after you have been out for more than 6 months, you essentially would have to start the clock again on the 5 years. Now, the difference between the deal and the no deal scenario is that in a deal scenario, you would have the fairly simple option of coming back to the UK before the 31st of December 2020, and you would be caught by all the benefits and rights that would be afforded under the withdrawal agreement. If there is no deal, you would essentially be in a position where you have to wait and see what the immigration system looks like at the time you want to come back to the UK. So if you're here before or on the 29th of March, you will be okay, because those who are residing in the UK on the 29th of March in a no deal scenario will be afforded the rights and benefits that they've had. But if there is no deal and you are coming back as a European, or you wish to come back as a European national after the 29th of March, there may be restrictions on how you can come back and what you might need to do to be able to come back. That's the grey area I was referring to earlier. There's currently no real process in place, no information available on those coming after the 29th of March. So that's one to watch.
Thank you, Denise. I think that we've gone through quite a few of the questions we've received. I hope we've covered all of the points that people wanted to ask on, and looking at the time, that probably brings it to a good conclusion. I'd just like to say thank you for your time in attending the webinar today. And I hope you found it informative and interesting, and you've learned something by joining. Probably an hour is only a scraping of some of these topics, but certainly you can find out a little more through our own details. You can find through, as I mentioned earlier, the Brexit Navigator at kpmg.co.uk. Our concluding advice is that businesses continue, or for some of them, start their no deal planning and their contingency plans, putting them into action. And again, thank you again. Thank you to Worldwide ERC for hosting us, and we look forward to speaking with you again on a future webinar.